You believe you suffered significant harm and injury as a result of the doctor's carelessness. And now you're contemplating bringing a lawsuit and you want to know, is it possible to settle your case before you actually start a case? Would you like to know what this is about? Come join me as I wait here in the car for my wife as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The short answer is yes, it is possible. Does it happen often? No, it does not happen often. Here's a scenario in which that might happen. Let's say something happened to you that was so clear-cut that if you just present the facts to anybody, they're going to know immediately that something was done wrong. They're going to know immediately that you suffered significant harm and injury and that your injuries are permanent and lifelong. Now, why would the defense be willing to agree to settle a case before you ever start suit? You know, you hear about people saying, okay, I'm going to threaten the doctor with a lawsuit. Certainly his principals and the people that are responsible for him are going to immediately acknowledge that he did something wrong, and they will immediately want to try and settle this case before we ever start suit because they don't want publicity, they don't want the notoriety associated with what actually occurred and the results that occurred. All of those are valid points, but not for medical malpractice cases. Many times in other types of civil cases, other types of personal injury cases, that may be true. In medical malpractice cases, it is rarely true. I have found that the people who are responsible for the doctors in terms of holding them accountable, those people, those principals, tend to want to fight and are willing to fight for the doctor tooth and nail. And they are willing to spend great deals of money to show to the doctor that they are willing to stand up to the attorneys who represent injured patients, known as plaintiffs. And many of those doctors are resentful of the fact that a lawsuit is brought against them, and they cannot understand why a case is brought against them. And they turn around and say, I'm going to fight tooth and nail. I'm going to fight this case till the very end and let a jury ultimately decide. I'm not settling this case for a dime. When you have that type of motivation and that type of feeling behind denying or refusing to want to engage in settlement discussions at an early stage, then to answer the question that I just raised, is there a possibility to go ahead and try and settle this case before you start a case, known as pre-suit settlement? The answer is it's going to be very challenging and very difficult to try and do that in that instance. There are cases, however, medical malpractice cases in New York, where it is so clear-cut about what happened, where nobody disputes the facts and nobody disputes the fact that the doctor or hospital staff involved were careless, that they departed from the standard of care, that the carelessness was a cause of this patient's injuries. Nobody disputes that whatsoever. The dispute, however, comes in terms of coming up with a value of the injuries. Many times when somebody tries to engage in settlement discussions before a lawsuit is started, they have to understand that if negotiations are started from the other side, from the doctor's standpoint and his principles, they understand that, look, there's a benefit to try and settle this case early. And the only benefit from the doctor's standpoint to try and settle this case early before it ever gets put into suit is to obtain a discount on the value of this patient's injuries. That's it. That is the only real benefit that the defense sees if we try and engage in early settlement discussions. They see an injured party, they see an injured patient, a plaintiff, now trying to resolve a case before the case actually gets started. They may be willing to accept responsibility off the record. They may turn around and say, look, we recognize that our doctor did something wrong, and we recognize that that wrongdoing caused significant harm and injury. However, what we don't agree on is the value of your client's injuries. We think your client's injuries are worth only X. You believe your client's injuries are worth X times Y 10 times. So there's a clear disparity and a clear dispute between what we believe the injuries are worth and what the defense believes the injuries are worth. In that instance, negotiations, even though they may get started at the very beginning, may break down. Why? Because even though they admit wrongdoing and even though they recognize that the wrongdoing caused injury, that does not now equate to the value of your injuries. So many people think that just because the doctor did something wrong. And just because the defense acknowledges that that wrongdoing was a cause of your injuries, don't think for a second that that equates to an increased value of your injuries. Now, maybe the value of your injuries truly are worth what you claim they are after the entire litigation process of 2 or 3 years. Maybe the value of your injuries truly are worth what you claim they are after a jury comes to a conclusion that yes, you are entitled to a verdict in your favor, and yes, the value of your injuries are exactly what you claim they are. Maybe the jury comes to a decision that your injuries are worth much more, which is certainly a possibility. But now you're going to have to go through the entire litigation process and to go to trial after 2 or 3 years to reach that conclusion. Then you're going to have to overcome the hurdles of trying to get your case thrown out after the discovery process when the defense tries to make a motion for summary judgment, which means they're going to ask the judge to throw your case out before you ever get to trial. And if you are successful and overcome that motion to dismiss, now if a jury agrees with you, and now you get a substantial verdict in your favor, you are then going to have to overcome the appeal that will certainly come based upon a verdict that was far in excess of what you thought the case was worth. In that instance, now you are going to have to go through the entire litigation process 2 or 3 years down the road and an appeal in order to validate and justify that your case truly is worth what you claim it to be. And in that instance, now there may be the opportunity to try and settle your case during that entire process. However, the defense may turn around and say, look, after the entire lawsuit process, yes, maybe your case is truly worth that amount. But if you want to settle this now in the middle of the case, we believe we're entitled to some sort of a discount. And so now, as an incentive to try and settle it early, we are willing to give you this amount of money. Now, let's go back to the question I raised at the very beginning of this video. You're trying to settle this case before you even start a lawsuit. Where is the incentive to the defense to try and get this case resolved before you ever actually start a lawsuit? And the incentive for them is to get this case resolved at a much lower value than what you perceive your case is worth. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand and to recognize that just because you believe you have the strongest case possible, it does not necessarily mean that the defense is going to agree with you in terms of what the value of your case is. I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter happened in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.